Hello and welcome back to the Data Privacy Lawyer. My name is Funmi Owolabi and I'm the principal attorney at the firm. Today's review, we're going to be looking at some AI terms. Why do we look at AI on a privacy law firm's channel? We look at AI because AI and privacy and personal data work hand in hand. We're going to see that. We've seen that in a number of different AI reviews that I've done. The value in talking about AI is because many organizations are trying to roll out artificial intelligence in some capacity within the organization. And we've talked severally on the channel about how personal data is a necessary component in every business. So it's going to impact artificial intelligence in some capacity. Now, that could be from the customer side or from the supplier side, but essentially every business, irrespective of the role they're playing in a business transaction, needs to be able to understand the personal data implications on their business, whether it's as a customer or as a supplier. And that impinges on the use of artificial intelligence too. So we're going to see something very interesting here. This particular AI agent terms of service not only states the terms of service, which we're going to review, but it also mentions their privacy policy, right? And any other appendices or agreements specifically referenced herein, right? All of that is the agreement. Now, let me tell you why I've called out the sentence. I've called out the sentence because when you have a data protection lawyer, the traditional privacy documentation is this one, the privacy policy. That is standard. A privacy lawyer is going to help you draft, amend, and maintain your privacy policy. However, when we look at things from a business context, many businesses don't think that they need a privacy review of their terms of service and then other additional documents that make up the agreement. But the reason why it's really valuable to have the privacy lawyer look at all of them, and one of the reasons why I started doing terms of service reviews on the channel, is because there is provisions, and we're going to see them in a moment, within each of these documents that impact the personal data. The first thing that on the customer side you need to know is review the provisions that are appearing in the terms of service, the privacy policy, and any other appendices. You need to make sure that you can reconcile each of these comments. The provisions that a supplier provides you in each of these documents need to align. If they don't align, you have a problem, okay? If I'm saying in my terms of service that I use personal data to provide a customer service, but in my privacy notice, I'm saying that I distribute it to third-party vendors and I'm not detailing that in the terms of service, then we've got a conflict, right? And then you as a customer need to go back and either, one, bring this up to your supplier, or two, you need to be looking at, oh, is this something that we accept in our own privacy program? And is this a practice that is acceptable for us as the customer? And then you also need to reconcile that in any additional appendices. When we look at the contract negotiation stage, we're not just looking at one lawyer looking at the privacy policy and then another lawyer looking at the terms of service. You need to make sure that your privacy lawyer is looking at all of these to make sure they're in line with what you can accept as a business when you agree to work with a supplier. Okay, I'm just going to hover over the actual AI tool. I'm guessing it's something to do with creativity. I don't know the tool itself. But another thing that a privacy lawyer would do is they will review what you as a customer can accept based on your own internal documentation. That's not something your supplier is going to have access to. That's something that you keep internally. I've talked a lot about what constitutes a privacy program. It's not just about these public-facing documents. This is not the only thing that an organization should have, whether supplier or customer. You should have internal documents that you follow on a strict regime about how you as a company treat personal data, irrespective of your relationship with any vendors or partners. And the internal documentation should influence the types of suppliers that you allow around your personal data, because your responsibility as a controller does not change just because you have engaged with a supplier to provide you a service. I actually wanted to get into the privacy piece. Let me just scroll to the bottom. Okay, interesting. So the AI agent terms, it looks like has included by reference an AI privacy policy. It also says here that they're committed to safeguarding privacy and operating with secure SOC 2 language models on Microsoft Azure. They also ensure compliance with CGPR. I'm not familiar with this law. I think this is meant to say GDPR. So I guess that's a typo. Now, the GDPR, for anybody that's new here, the GDPR is the European Union privacy legislation that dictates how the personal data of European Union residents can be processed. I think that's what this is alluding to. I've talked a lot on this channel about geography and how influential it is to the type of privacy program a supplier has and their adherence to that legislation, and then the type of privacy program that a customer has and their adherence. Let's say, for example, you are a US organization and you are liaising with a supplier in South Korea. Now, if the South Korea vendor does not adhere to US privacy legislation, you need to see and understand whether or not your privacy practices can accommodate how they will be treating your personal data in their geography. Every privacy law is not the same, and your obligations are not the same. And this is why I've talked about on this channel before, why I think it's a bad idea to purchase a boilerplate privacy notice off the internet without having additional legal review, because just because you've received a boilerplate template doesn't mean that the provisions align with what your organization is doing. You need to tailor make it, right? And you need counsel to ensure that you're meeting your obligations outside of just purchasing a template off the internet. What I highlighted this because I wasn't familiar with that particular law, but the reason I've highlighted it as well is because it gives us an indication potentially to the laws that the vendor is taking into consideration when they're building their own privacy program. These terms are kind of short. We can actually, for a couple minutes, let's look at the AI privacy policy. This was last updated 2 years ago. So I think this is definitely something that needs additional review. I've talked in other privacy notice reviews about the importance of doing a periodic review of your privacy documentation for a number of different reasons, right? At the beginning of this video, I talked about how artificial intelligence is a new area that is brand new for a lot of businesses when either integrating or creating their own AI tools, systems, applications, etc. If how your AI uses personal data is not reflected in your privacy notice, you put yourself and your business in jeopardy of being not transparent. And transparency is very important under the data protection principles. So if your privacy notice doesn't reflect what you're doing internally, there's a law called the FTC Act Section 5 that talks about not being unfair or deceptive in your practices, which looks at things in a privacy context, in not misleading your audience on how you're using their personal data. If you're introducing artificial intelligence and you haven't captured that in your privacy notice, you put the business in jeopardy of being unfair or deceptive. I clicked on this because I thought it was going to be AI specific, but it appears that we're just back on the privacy notice itself. The one last thing that I'll talk about related to this particular review, originally I wanted this to be about the terms of service, but they're kind of limited. Without understanding as a privacy lawyer really the ins and outs of your products and services, it's difficult to provide true advice. But I think as privacy counsel, we can make different types of opinions about what it is that businesses are doing based on the representations they make on their site. They are telling us as consumers, and I am a consumer of this organization now because I've landed on their storefront. The storefront here is the website. In landing on their storefront, they are going to be collecting certain types of personal data about me. How do I know this? Let's click on this, right? So they've got some accessibility here. I thought this was going to be a cookie preference center. I'm just going to scroll down. So there are cookies being collected. Do you see that? Necessary and essential cookies. They've got cookie policy notice acceptance cookies. Essentially, there are cookies being collected as I interact with this online storefront. And I haven't been presented the opportunity to exercise my options when it comes to whether or not non-optional cookies are being collected as I interact with the storefront. So there's a lot that's actually going on with this particular review. I really didn't want to review the privacy notice because this was meant to be terms. But I think the last sentence I'll say here is that the terms are influential during your contract negotiation phase, and they're also influential during your vendor due diligence phase. And as such, they should form a component of your privacy program, and they should be a documented process on how that is conducted by every organization. So I really hope you enjoyed this review. If you have any additional comments to add to what I've stated here, or if you like this type of content, you like looking at different privacy reviews, you like to see the privacy posture of different organizations, you like an opinion from somebody that does this on a day-to-day basis, subscribe to my channel and I'll see you in another review.